So we'll start out with kind of the brief synopsis of the statute you filed, you challenged the constitutionality of, and kind of where that sits right now.
Okay. So I'll be as quick and as general as possible, but every state, and I'm in Minnesota, so every state has a statute that says if two people split, get divorced, custody, whatever, how do we sort out parenting time? As you mentioned, Arkansas, is that what you said, is now 50-50?
Arkansas and Kentucky are the only two 50-50 states.
That is awesome. So by default, you split there, and it's 50 for mom, 50 for dad. That's go ahead.
Yeah, so Kentucky it's a presumption of 50-50 and you have to by preponderance of the evidence prove that that's not in the best interest of the child or children. And in Arkansas, it's a 50-50 presumption, and it takes clear and convincing evidence to rebut that presumption.
That's that. And just for everybody who's listening, the difference between preponderance is 50.0001%, and clear and convincing is generally recognized as 85%. So clear and convincing, that's what state did you say was clear and convincing?
Arkansas. Actually, today, I believe it actually went into effect. The Arkansas law officially went into effect today.
So that is a huge victory for parents and for children. Okay, so those would be the top of the bar. Those are constitutionally A+++. Now, if you have a state like Minnesota, you split, you only have a 25% parenting time presumption, right? So that's all you get instead of 50%, leading to custody battles, et cetera, et cetera. This is the problem. This statute that says you are presumed to have 25% minimum parenting time is problematic. It should be 50. And the question is why? And the answer is the Constitution. And what specifically about the Constitution? You know, we have the First Amendment, the Second Amendment, Third Amendment, the 14th Amendment. And it might be useful to read the 14th Amendment, but it's the due process clause, right? The 14th Amendment is long. The last clause says that we have due process of law. And what the Supreme Court has said that to mean is like, look, we've decided as a Supreme Court that parents have a right, they use the word right, to their children. And we have decided as the Supreme Court that you can't take away rights without due process of law. And then we can go into strict scrutiny and what that means. But here, if you have a right, it means, and we're all equals in this country, that's due process of law, equality under the 14th Amendment. It means that parents should have equal time with their children, right? We're entitled to equal protection of the laws, equal protection underneath the 14th Amendment. So that's the constitutional claim, and I think I'll pause there before going deeper. Mark, is that in your eyes the 30-second nutshell about what's happening?
Yeah, I think that's right on there. It's that this 25% presumption, and you were right on. Every single state's slightly different, has different wording, is codified differently, but essentially what we're looking at with the constitutionality, I believe the Supreme Court case calls the right to parent a fundamental liberty interest, I think is the actual phrasing and wording in there.